So I see many of you, we talked outside about the legal issues, super, so let's go on. I love law because it's not about the journey to the moon, it's about nowadays and long-term strategy. So it's very important, and I want to speak with my dear friend, colleague, Konstantin, about the crypto fraud, real cases, application of all this stuff nowadays, how it's going on, and about the smart contracts in the real business. So tell please, today unfortunately many people, they are facing crypto fraud. They are losing a lot of money. But how it is look like in reality? What kind of criminal cases do you have, and what kind of crypto frauds did you face personally as a lawyer?
Thank you, Petro. So my name is Konstantin, and I have been doing this business for 10 years, especially in the financial sector, and I'm doing that also into the crypto sector. So I think I should start with the conclusion. Don't become a victim of a crypto fraud. You have less than 1% chance to recover your assets. So that's the conclusion. What is happening, let's say, most of the cases. So I can give 3 examples for my practice. A wallet hack, for example. Your Bitcoin, Ethereum, they went somewhere. Usually what we call the investment scam. Someone tells you can make a lot of money, but the payment investment should be done into a cryptocurrency. And I have a very interesting, I'm not sure that a lot of people know, I have a case of payment with fake USDT based on smart contracts. So for the fake USDT, it looks, from the technical point of view, I'm not a technician, but what I understand, it's a smart contract where you create, in a way, a USDT, which looks like a real USDT, but has 0 value when it comes to a on-exchange platform. So what can you do when you're a victim of a scam, knowing that you can trace the transaction, but you don't know the exact identity of the person who received your transaction? So this is the most difficult part, because you need public institution to assist you for the, let's call it, the disclosure procedure of the identity, and they can assist you only when you trace a transaction to an on-exchange wallet. That means when it is outside the exchange, nobody knows who is the keys. When it's into an exchanges, the exchange knows the KYC, the identity, and needs to disclose it to the public, usually to the criminal public institution. Here, all this procedure takes a lot of time, needs to be prepared, and you need, depending on the authority, you need to make them understand how all is working. They need to check in order to ask the relevant exchange for this information. When you receive this information, this is now, at least you know who get the benefit of the transaction, of the cryptocurrency, but then you need to prove that he's really into the scheme and not a middleman who actually is just performing a normal transaction, thinking it's a normal transaction. And of course, in each case, they say, I have nothing to do. And he tries to make a story why he received this from these friends, a lot of stories, etc. But you need also to challenge all these stories. And at the end, you need to freeze the cryptocurrency if it is still into his wallet or if it is transferred to another wallet. So technically, it is possible now, more and more, to be able to freeze wallet when they are on exchange, of course. It is the same kind of procedure than to freeze a bank account. Because to understand correctly from everything, I'm not a technical expert, but what I understand is that when it is off exchange, When it is off exchange, the crypto is like paper money. When it is on exchange, it became something like digital money, and then in a bank account, and then you know who is behind. And so it is possible to freeze on exchange, to freeze a wallet on exchange, and after that do the civil or criminal procedures to recover the stolen cryptocurrency. But by saying all this, I say it very generally because I can now very, very quickly enter into a more detailed and more complex, because you have, let's say, procedure as much as jurisdictions in the world. Let's talk about Europe. You have 27 countries, 27 different jurisdictions. And when it is international, usually the cryptocurrency scams are international, you need to play with each jurisdiction differently. Depending on the fact, you may need to go into one jurisdiction, another jurisdiction, one for the discovery, the other for the freezing, the third for any kind of asset recovery, and it becomes very, very complicated. The last point I want to point out is that, unfortunately for us in the continental law system, which means most of the continental European system, we don't have what the Anglo-Saxon law has, which I found it very good and very efficient. This is pre-litigation disclosure. Why? If you are in an Anglo-Saxon world, you may by yourself try to make a disclosure procedure against an exchange without the need and assistance of the public authority, and obtain such information and prepare for freezing after that, and prepare the whole procedure of asset recovery. However, in our continental jurisdiction, most of them, but especially for Bulgaria, we don't have pre-litigation disclosure procedure. If you want a civil disclosure procedure, you need to start a litigation. And when you have a cryptocurrency transaction, to start a litigation, the first and most important thing is to know who you're gonna litigate. But you want to understand who you're gonna litigate, but in order to litigate, you need to know it. So how are you gonna do that? And you are obliged to pass through the public authority, which of course is very tough and complicated. It takes time, and the whole public authority, I'm not entering into the detail, it depends a lot of the local institution, people understanding the crypto, etc., etc., which also makes things harder and harder to resolve. And of course, public authority, most of the time there is coordination in the European Union, but when we are talking about even millions, they are not really very excited to make a lot and fast procedure. Usually they have, they are assigned to talk about billions. They are assigned to talk about big company, very important social impact of a given cryptocurrency fraud. For smaller, without a social impact, they will not be very fast. And here, if they are not very fast, of course you are losing, by losing time, you are losing a lot of chances to recover and to reach the identity, the freezing, and after that, the recovery of the crypto assets. So what can change right now, and there is a light in the tunnel, is that there will be far more transparency now with the MIC. That regulation would allow more liability, transparency, and it will be easier to know against whom you're gonna go, the crypto exchange, what information they're gonna provide, and if they failed, the crypto exchange is failing to do the job, is allowing a fraudster to use their infrastructure for money laundering and crypto fraud, then you can even go and try to litigate the crypto exchange itself, because he allowed the fraud, and even if you are a third party, the victim, company, whoever it is, the crypto exchange would have far more liability right now for allowing illegal money laundering transaction happening into their hot wallet and into their internal system. So I think for the asset recovery and for the people victim of such kind of fraud, I think the future may be brighter, even though there will be less privacy. That's another thing we were talking, etc. But when there are less privacy, then it may be more difficult to get the bad players. When there is more privacy, more public information, more accountability, it makes more easy for us asset recovery to go and to find someone liable on the chain of each kind of scam and transaction, and that allows us to do better job and to have an efficient recovery, which it doesn't mean 100%, but even if you get 10, 50%, you recover. Usually this is a huge success in such kind of cases. And so now we're gonna switch to talk with Petro about the smart contracts, and are the smart contracts a way for more security of the transaction and to avoid potentially such kind of fraudulent behavior on the blockchains?
Thank you very much. Thank you for your speech. Actually, I think that smart contract is a tool that can help us to avoid all these financial crimes. If to speak from the legal point of view, what is a smart contract? Smart contract is a computer code that executes automatically the terms of any kind of agreement. If to see more precisely to this code, so this is the mathematical functions with the numbers. And the logic is quite easy, if, yes, no. So the same scenario works in traditional paper documents. So we have, in an agreement, we have information about the parties, about the object of the agreement, rights and obligations, cost of the services or the goods, time when we have to execute it, and fines if we breach this contract. So it works the same in a smart contract. So the same, if, yes, no. The main thing in smart contract that there is no room for free interpretation of its terms. So if, according to the smart contract, we are buying, for example, NFT that's prescribed to be white, and we make this transaction. So we cannot say, and you send me, for example, I don't know, black NFT. I cannot say, oh, I saw that this agreement was about this kind of NFT. Maybe if you look at this site with the color, it will be white. No, it doesn't work so. So with a smart contract, it works automatically. And then after, if you are not agree, of course, you can go and try to defend yourself in the court. But again, this is a theory, but in practice, how does it work and how it can enhance purchaser experience? Now I'm working as a lawyer in one project. They're building a classical marketplace for buying used cars using the smart contract. So how does it work? When we based now in Bulgaria and we want to buy the car, I don't know, in Spain, for example. So, but this road is very long, and we have to find a lot of people first to find the car, then to check somehow its technical side, if it is okay, can it move, and so on. Then to find someone who will do this job, then insurance, transportation, lawyer who will go to the local authorities and take registration number. But it takes a lot of time. And we have to find all these service providers. And if we are not in this sphere, it will be very difficult to find someone whom we can trust. And of course, it will be much more easier to find some intermediary, some company who will do it like in one box solution. But in this case, with the help of smart contract, you can choose the option of the insurance, of the transportation, and so on, just with the price that you like, and then you make it all in one smart contract. But the question, why it is secure for you again? So where is the trust? Let's come back to the very beginning, the essence of the crypto, why it were created, a white paper of Bitcoin, and the answer is there. First, we have to protect the sellers. So when we give the goods, we have to receive money first. not to go to the court and say that this good is not that we agreed before. And second, it's the essence peer-to-peer. So we, as each service provider is this chain, actually is a node from technical side. And if to come back to the essence, so each node working for the chain. So if the chain feels itself good, trusty, and everything goes well, we're acting in a good phase. So you as a node also will be in a good position. Everything will be good with you. So let's come back to this marketplace, global of the chain. When you as a service provider, definitely you give the services and maybe something goes wrong and at the end of the day we can go to the court. But again, if it was your problem, if you breach the contract, your obligation, so automatically with the help of the smart contract, immediately you will lose money that can be staked. So again, we are avoiding all these long procedures, going to the court, explaining who right or wrong, and so on, so on. So smart contract helps to do it much better. By the way, last December, International Trade Organization and European authorities in its data regulation, they accepted smart contracts, they recognized it. What does it mean? So it's a legal base now to use this perfect tool in any kind of web to business. So it enhances, first of all, speed of any transaction, security, and reducing the cost because we avoid intermediaries. But again, one more, how we can be much more trusted using the smart contract. Smart contract, due to its DLT technology base, its transparency, this smart contract can be tested by many other peoples. By the way, when you're even not a lawyer and you're reading a classical paper agreement, not everybody understands what it is exactly about. Even the terms of use, people never read it, but it's legally very important document. But this smart contract is open, everybody can check it, and also due to this transparency and DLT, you can order to specific companies who do a security audit, legal audit of this smart contract, and then you can say that yes, it is reliable, we can use it. So I think smart contracts is the next step, not for a future for the moon crypto, it's next step for the Web 2. And we have to use this perfect tool already, right now.
Okay, so maybe if anybody has any question, we can discuss about the topics.
Actually, I have one question.
Yeah.
Can you please tell the guidance for the victims who faced fraud? So step by step, what they have to do, how they have to, and what evidences they have to collect in the very beginning before going to the lawyer or maybe someone else.
So when it is about a crypto fraud, of course they need to gather the evidence about that transaction. After that, we need to make a cryptocurrency, crypto tracing report to identify any exchange that we can ask for the identity. And after that, if we are into the continental system, for example, Bulgaria, we need to go to the police or the cybersecurity department here, cybercrime, and ask them to go to the exchange and to get information. The major problem is that the exchange, we never know who is exactly the exchange. So, yes, according to the current system, each exchange should have a kind of VASP in a given country. I'm talking about Europe, but it's very messy, it's not recognized everywhere, and even if you don't get a VASP, you can still make transaction. And the fraudsters are usually trying to identify crypto exchanges regulated somewhere into Vanuatu, I don't know, whatever jurisdiction when, frankly, it's a small island and nothing happens, of course, on that island in terms of potential asset recovery. And when they approach for any kind of information, they don't know, even the police doesn't know who to approach, who to ask. So that's, I hope, will change right now, Because right now, if technically it's possible to avoid any services of an exchange with an IP outside the European Union, and I don't know how it's going to be technical, but if you are using always as a European citizen or company European established exchange, that would be very helpful. And with that exchange, after that, unfortunately, if the exchange on the other side happens to be outside the European Union, and again someone else, that would make again huge problems for the recovery. But the fact that there is in Europe base may give more liability.
There is a huge, I want to add, if you allow me, there is a huge issue now in the legal society. It's quite possible that we all here, and we too, we are somehow interconnected through 1, 2, 4, 5, 10 wallets, crypto. It's quite possible. And it can be traceable. So the question is, if we all who are interconnected, and some of us is a crimer, and he did something very bad, does it mean that everybody who are in this chain also a part of this fraud scheme or criminal activity?
This is exactly I said. So that doesn't mean, and usually you need to ask them why he received such kind of crypto, and he's giving a story. He explains, I received this because it's a friend of mine, or etc. So depending on the story, sometimes the story is very funny, and it's obvious that he is into the whole chain and asked or paid in order to give assistance from his wallets, on exchange wallet he's paid. But sometimes, yes, the story could be true. He bought, it depends on the quantity, of course. He made some fake contract or some contract, and he tries to explain that it's a true story and there is a true service, delivery of good, etc. But this is gonna be even with the MiCA a huge problem, and there it depends on the story of the person.
There is an issue that in the end of the day, this litigation will be solved by a judge or a prosecutor or someone else who are actually not familiar with the crypto. They don't know what is DLT, how does it work, so it's something amazing for them. So as for me, what is very important in such cases is data analysis. So it solves a lot of problems. Data analysis based on the specific requirements and the specific activity, not only why you received this money, but how many times did you interact it, why you interacted, the amount of the assets that you sent, how was it connected in time perspective with the first fraudulent transaction. Actually, all these requirements now, they are prescribed in FATF recommendations, so it is quite obvious. The question is to make this report, data analysis report, much more obvious for everybody who are not familiar, but who make a final decision. How do you think? Can it solve this problem in such way?
First, I think that into the legal community, it's very important because the data analysis, I understand that like the crypto tracing, data analysis, this is very technical, and how a judge or a public prosecutor will understand it. So this kind of education about how works a given system, especially when you have judges who are at the top of the career and they don't want to get into the crypto. For them, it's too much for them. So you need a new generation, preparation of a new generation of public prosecutors, judges, police officers in each country in order for them to be able and familiar with the technology in order to understand these crypto reports, and that the specialists who are presenting this report or work into their department are able to explain them. So that's a process that I know that in the United States it's quite, they are very good, but here into especially Eastern European country, that process will take maybe longer compared to the United States and the Anglo-Saxon world. That invented, by the way, the crypto industry.
Thank you. That was really interesting, first of all, so thank you very much. It's a very cool presentation. I have one question on the data analytics side. To what extent can you use these data analytics tracing tools like chain analysis and elliptic in these sorts of cases? Do judges accept them? Are they used? Are they too expensive for retail? Because I know they're pretty expensive. What role do they play?
Look, all these reports are doing according to the specific recommendations. And today there is no official recommendations, there is no guidance. But in Europe especially, there is a principle of a good faith when a company who is doing this report checking all possible scenarios that can be applicable to this specific transaction. So if the company well known, has a good experience, have a good cases, and any DLT is transparent, we can do on-chain analysis by ourselves, just using Etherscan, whatever. But these reports, they can make it not like numbers, but a picture. You can see these interconnections with the wallets. And there are many not recommendations, many approaches, red lines, white lines, green, and so on. So it just helps us. It's a tool, it's a muscle. But at the end of the day, judge will consider if these interconnections are worth to consider them as illicit.
So if I just want to add, you're talking about public institutions. So to the best of my knowledge, I think that even the Bulgarian cybercrime are using tools like chain analysis. This is to the best of my knowledge. But for example, for litigation in Bulgaria, that's different from the Anglo-Saxon. The expertise, because this is an expertise. There could be a lot of expertise used as a factual document, etc., that shows some facts which are of importance for the trial. Such expertise should be done by people who are listed in a given register in Bulgaria. How many people have the expertise and have been listed and have an interest into doing such a kind of expertise? Actually, I'm not sure there is any, or if there is one or two, and I'm not sure they have really the real technical experience. And why it is different? Because in the Anglo-Saxon, you have the right to bring your own experts, to the best of my knowledge. In the Anglo, here, you don't have the right in a civil court to bring your own expertise. The expertise should be done by an official, which could make a litigation a problem of expertise and a problem for the judge to understand what is happening and what are the facts.
That's a really, really interesting expert witness, because it touches on something, which is anywhere where there's money to be made in crypto, you have fraud. And an area that I see increasingly is the so-called experts on analytics who are actually just fraudsters. They don't actually do any analytics. And you even see it in the Roman Storm trial in the US. They brought their own witness who was an expert who was an idiot. Like a 14-year-old kid, could find out what they didn't know. And so it has an upside and a downside. I like this idea that there's a register of experts and only they can come. You just have to find the expert in the first place, as opposed to bring your own, because right now the whole marketplace is flooded with thousands of alleged AI analytics companies, which there's nothing going on there. It's empty. And they're just just trying to get money. So.
Yeah, so basically this is the general conception of the continental law, which is different from the Anglo-Saxon. Here, for example, there is, and what makes my job very difficult, when there is a crime, like a scam, a fraud, let's call it a fraud and money laundering crime, under the continental system in Bulgaria, there is a monopoly of the public institution to investigate it. You have no way, you as a private investor, you may have a lot of money, whatever it is, but you have no way to investigate. And even if you make your own investigation, it means nothing, because you cannot use it into the court proceedings. You have your investigation, still nobody cares about it. The police should make the investigation, etc. I show it to the public prosecutor. They are in charge. And at the end of the day, all the information you got, you may try to make a litigation, civil litigation, but the concept in our jurisdiction is that the civil should follow the criminal. That means they have to start a criminal accusation act against the fraudster. And within this procedure, you can start your civil material claim for the damages, blah, 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 blah. And as everybody could understand, it happens very few times. That you got the identity of the scammer, the people, the freezing. The state should freeze also the asset. The state could do whatever they want, time after time, and make an accusation. If they have not frozen the assets, for you as a victim, why do you care they're gonna go or not in jail if there are no more assets? And everything is a kind of monopoly by the public institution. Whereas what I like into the Anglo-Saxon world is that you can do by yourself. You need money, of course, a lot of money, but you can do such kind of procedure by yourself to have a security on the freezing. Once again, if I want to freeze an asset, I need to freeze it and just after that start a civil litigation against the fraudster. I cannot just freeze an asset without starting a litigation. How do I understand who is the fraudster? I need to go to the judge to say, look, he is. If I want to freeze it against Binance, I say to the judge, it's Binance, maybe I will get freezing, but after that I need to litigate against Binance. Why? Why? I don't know if Binance have, just to receive by myself the identity of the fraudster. That doesn't work. And that's the whole difficulty, and we can put more specific European difficulty. This is that the police investigation into such kind of international, they need coordination. It takes time, because you have 27 states. It takes time, and there are some, as I said, priorities. They have their own priorities, and if it is not a very important for case, we're talking just about million, it will not be within the priorities.
Answering to your questions, I can talk hours about this. It's a really huge problem that there is no methodology how to make this on-chain analysis, really. But let's try to be out of the technology. And this is the same financial crimes. Transactions between classical bank accounts of different kind. Assets is money in this case. So there are a lot of cases already existing, and they are putting into the base of any kind of litigation. And there is a specific economical accountant expertise. So if you have any kind of transaction and you have some deposit, please explain why you received it. If you cannot explain it, so this transaction is unproved, that's why we can consider that it is illicit. So the only actually problem, or maybe the difference with the crypto fraud, that there are can exist hundreds, thousands of intermediaries, wallets, who are splitting the basic stolen assets into smallest piece. First and second, we cannot say that we cannot mark that asset that were stolen. So this is the only problem. But again, if to see to this picture globally, as a picture, I try in all my cases, I'll try to show a picture that can be obvious for everyone who are even not familiar with DLT. And then when people see it, okay, there are different approach. But again, everything already exists. Classical, accountant, and economic expertise.
So do you have any questions?
By the way, the same problem exists with the smart contracts. So there is also no court cases now. So now I found only 2 cases related to crypto. One in Singapore, the company who helped to make some investment, and the question is what exactly this investment was about. Was it about just crypto asset or something? But it was 3 years ago, but now everybody understands what it is exactly crypto asset. And another one is in Netherlands about the Bitcoin, when it was the obligation to make a transaction wasn't fulfilled. So court decided that the damage was, the sum of damage shall be counted at the moment when the obligation to send this asset wasn't fulfilled. So this is the only cases about crypto now existing in Europe. So just imagine what will be the eyes of the judge when they see smart contract is a huge code and some obligations and some arguing between parties. This is the question. But again, we need some time. Now in USA, they are making all these cases about the crypto fraud, DeFi protocols, what it is exactly DeFi. Now there is a huge case about the market makers. So this is a very painful topic. If to say from the legal retrospective, market making, the only thing that can be done as market making just to execute the order, not to push down or up the price. And then you have to notify local authorities that you have done. This is the only market making. But in crypto, unfortunately, it works in a little bit different way. But why, if everybody understands it, why exchanges still requires market making support before listing? But I think time needs to get to it.
Yeah, I think that the smart contracts should at the end be regulated on a kind of European level in order to be useful, in my opinion. And for people to have a normal business, have more confidence, and to have a kind of clear definition, what kind of technical service provider should be done, etc. This is my opinion.
By the way, why crypto will exist forever, it's obvious for me, is traceability. So any activity that you're doing with the crypto assets can be traceable. And someone who has a just good mind and some good practice, he can analyze your activity, understand what exactly is happening. So you told something very perfect. So class dollar is the tool that's are not controlled by anyone. Crypto can be. So it creates huge opportunities for the governments, but also from other side, from good side of the coin, it creates a good opportunities for the investors, for the business, for the transparency, enhancing of the interaction between seller and buyer. So we can and we shall use this instrument in our activity.
Sorry, I cannot help myself when you say the smart contracts should be regulated by governments. I think you kind of completely missed the whole point of building these ecosystems. They were actually all built in order to avoid governmental control and create trustless systems where you don't need any government to meddle with it. So I think you're completely on the other side of the spectrum than that one.
When I'm talking a regulation, it's not about a regulation like a license. It's not about when I say to give a clear definition what it is, how it should be functioning in order to qualify as a smart contract, and to give also kind of technical details of how there should be a quality about all this technology, etc. This is the idea of kind of regulation, but not regulation in the sense of licensing. I mean clarity about the definition and what requirement it should be in order to qualify as a smart contract and be used between two parties.
I think
but not the content.
This is exactly where we really don't need any governments, and government should get as far away from it as possible. I think there is the fun part. I think I'm trying to get the AI to give me to assess the cost of the MiCA regulation and other EU regulations. But funnily enough, I would bet that they're far higher than all the value of the frauds. That the government is creating by far bigger damage by regulating these markets than the amount of frauds that are actually taking place in EU. But interestingly enough, it's hard to, even with Grok and with ChatGPT, to come to any sources. It seems they didn't even consider making a assessment study, how much damage are they creating. And of course the damage is huge because the regulation is fully retarded, and so the cost will be enormous on the EU markets, and the only result will be that we'll fall further behind all the rest of the world, and we are just going to make a Skansen to which Chinese tourists are going to visit the medieval castles here.
So, just my personal opinion, they did not regulate the market to avoid fraud. That doesn't make sense. I think they decided such kind of regulation, etc. This is for some political reason, for some technical reason, for some control reason. About the stable coins, etc. There are some financial reasons that are important for the government, but the fraud itself, first the control about the fraud started a long time ago with the I don't remember which directive said that crypto service providers are obliged entity for the AML purpose. So the control of the fraud started with the AML, but the MiCA regulation, I don't think this is to avoid fraud. But it would have consequences for those victims of fraud to have a better way to recover.
I'm very sure that all these regulations are there to impose more stealing by governments from the people and make bigger police state, right? Just so we're on the same line there.
Yeah. By the way, about the smart contracts, so again, let's come back to the essence of the crypto and the Bitcoin white paper. And it describes actually why it was developed, created, whatever. And there was no words about some anonymity or something like this. So if you're doing your job correctly, according to the law, why shouldn't be aware of some illegal activity from someone? So this is, again, the main task and why crypto exists, and we are all using this is the transparency, this is the safety, speed, and reducing the cost. So, and by the way, there is now in the EU Commission, they're discussing to oblige deployers to accompany the smart contract with the legal disclaimer for the consumer's protection, to explain for consumers to understand what exactly he is signing. I did personally many times. I made a huge mistake. I signed a smart contract, considering that I'm just signing in some website. But unfortunately, it wasn't so. I lost some money. But if someone described me that what exactly I'm doing, maybe I would make at that moment another decision. So why not? Why not to make these disclaimers? It is obvious.
Sorry, I didn't.
What about the legal principle of caveat emptor, buyer beware?
No, I didn't get the legal principle of caviar. Caveat emptor. What? Yeah, I'm not sure. In continental here we don't have that. But can you just explain what it is into the Anglo-Saxon? What does it mean exactly?
Yeah, so the principle of caveat emptor is Latin, and it just means, it translates in modern days to buyer beware. Like, so you're shopping and you buy something and it's not what you thought it was, it's your fault. Right. So that's a principle in Anglo-American law.
Yep.
And I'm not talking about like frauds where somebody drains your wallet and stole from you, but I'm talking about like the example that we just had there, like, I went to the website, I did a thing, I clicked on it, I signed it, and then the result wasn't what I thought I was going to get. As a general statement, at the baseline of the fundamental principles that are available in law and equity and Anglo-American law, the first thing I think about is caveat emptor. Mm-hmm. Like, tough luck.
Yeah, so that's the same into continental law. So first, it is important what you understand. Maybe it's important what you understand as a consumer you're gonna buy. And the analysis would be, if a normal consumer understands this and the product is different, then those who are offering the product are liable, because this is a misrepresentation, okay? So it is about the way a normal person will understand the core characteristic of a product. Normal person. The fact that you are stupid, you understand nothing about, you sign the contract, etc., nobody cares about that, okay? But you need, when you make an analysis, usually, if I understand this way as a lawyer, that means a normal person should understand that way. And when you go to the judge, he will say, yeah, a normal person will understand that way. Whether the client has understand that way or a different way, by the way, it doesn't matter. You know, into the kind of misrepresentation that we are talking about into the financial service, and now, by the way, it will be into the crypto service, because this is one of the most important principles into financial, how you advertise, you market, you present your product, and how your product should be understood, but not whether or not it will be understood. That's a different question. In my opinion, nobody cares about that. Okay, thank you.
Thank you. Let me please, one small remark. In law, there is a great principle, good faith. If someone who deployed the smart contract, he was acting in a good faith, so what was his intent? To take your money or just to let you to sign in? This is the answer to your question. So if his intent was illicit, he has to be punished and revoke all losses. Thank you.